My name's John Binns. I'm a financial crime lawyer with particular specialism in the Proceeds of Crime Act, which includes confiscation law. One of the many things that's unsatisfactory about confiscation law, in my view, is that it contains a lot of very misleading words and phrases. Confiscation, to start off with, is not really what the Act is designed to do, at least that section of it. It doesn't identify criminal assets that then have to be given up. Instead, it's about a personal order being made against a defendant after he or she's been convicted that they've got to pay a sum of money. And the court has to calculate what that sum is by looking at two amounts. The first one is the benefit figure, the benefit from crime, and the second is the available amount. And both of those things don't mean what you would think they mean. Benefit, first of all, means property obtained. So, of course, somebody can obtain property but not keep it. And a classic example is somebody who's arrested with a large quantity of drugs on them. The value of the drugs, it counts as a person's benefit, even though it may well have been seized from them and they don't have that benefit anymore. The benefit might also be much bigger than the defendant has actually obtained because he's committed offences via a company, and in some cases you can ascribe that benefit to the defendant. There are also a lot of cases where the defendant is assumed to have a criminal lifestyle, and what the court then looks at is not just the benefit from the thing they've been convicted of, but a wide variety of unspecified crimes in the 6 years preceding charge. And that's a tricky one, because you might think that somebody being found to have a criminal lifestyle deserves that kind of treatment, but in fact the Act deems somebody to have a criminal lifestyle if certain criteria apply, and it's not really about the substance of whether they did or didn't. It's just about what crimes they've been convicted of. So you have a situation where the burden of proof is reversed and the defendant has to show that their assets were legitimate in those circumstances, because the court's starting from the point of view that they have this criminal lifestyle. The available amount is also not what you might think it is. It's not necessarily available to the defendants, and the classic example is what they call tainted gifts. The idea of that is to catch the situation where a defendant has given away assets to their wife, say, to try and escape the confiscation system. But in practice it goes much broader than that. It doesn't have to be tainted in the sense that it could have been property given to any third party in the 6 years before charge, and the third party doesn't need to know anything about it, or it doesn't have to be done with that particular motive, so it's not tainted in that sense. And indeed it doesn't have to be a gift either, because it doesn't have to be nil value. It could have been sold for less than it was worth, for instance, and that still counts as a tainted gift. So if you put all those things together, you end up with the court making a finding that a certain amount is recoverable, and the reality is very much not that, and the defendant may end up serving a prison sentence for not paying something that he can't actually afford to pay.